Sometimes like all you want to do is run. Hear me out, hear me out. It's all the things you never show. There are the things I want you to know. Secrets start in your heart to slow. But if you don't wanna tell me now, I guess I'll never know. Losing almost all my energy. It's getting hard to talk to you, and I'm the only one who speaks. It's all the things you never show. There are the things I want to know. Secrets start in your heart to slow. But if you don't wanna tell me now, I guess I'll never know.
Okay, hey you guys, good morning. So I thought I was gonna stay in bed still. I was like, oh, I'm gonna stay in bed. Next thing I know, Adam sends me a document, and then a couple of minutes later, he sends me a couple more documents. So we have the motion, of course, to disqualify for judging. Good morning, you guys. Eyes are barely open here, to be honest with you. And then the other two motions are motion to dismiss filed, and then of course a memorandum, brief filed memorandum of law in support of dismissal. So basically, what the Supreme Court had said was unanimously that they weren't going to deal with any other motions, of course. So this isn't a big shocker here, I'm sure, to anyone about the judge Fran Gull saying that the court having the defendants verified motion to disqualify filed January 28, 2024. Defendant's affidavit filed January 28, 2024. And certification of Richard Allen's attorney filed January 28, 2024. Under advisement and having considered the pleadings. Yeah, I can't help but laugh every time I read that part. Now denies a verified motion to disqualify without hearing, as the Indiana Supreme Court unanimously denied defendant's previous request on January 18th of 2024. Okay, so I'm pretty sure that's not a big shocker to anyone on that part. And what's that song? It's called, I think, You'll Never Know by Track Tribe. It's a free YouTube one, or it's one of the better ones. There's a bunch of shit songs out there. I wish to see. Yeah, I know. I was just looking for that this morning as well. Between Law and Laughs, I was like, come on, court of opinion, let's go. Freaking, and I like how they said promptly. I don't know what their word promptly means, but obviously it's February 7th, and that was on the 18th. So I just happened to be looking at that prior to getting this. Hi, Elizabeth. I'm not sure, but somebody had sent me a $5 PayPal. I'm not sure if that was you or not. If so, thank you very much. Just because I remember it saying Elizabeth. But morning, everybody. Good morning, Steffa. Good morning, GP. Charmaine, how are ya on there? It gets so lonely during the days, I guess, sometimes myself, because Adam's at work, Charmaine's at work. Anyways, you guys, so let's see here. I'm going to stop screen on this one, and then I guess we'll bring up the this one here. So give me a second here. Boom, 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 boom. Oops. Is it in here? There we go. Okay. So, State of Indiana, Richard Allen, motion to dismiss for destroying exculpatory evidence. Hold on, let me just come back to you guys for a second. So I'll be on a different page, actually. So I'm just going to remove myself from here. Actually, I'm going to I'll remove this as well, make it a little bit easier for you guys to see. And then I'm going to quickly come back again. Oops, need to go back to the commentary. I I'm home for now, but can't come up right now. Oh, right. You're too busy for me. I get it. Was me. Okay. Well, thank you so much, Elizabeth. Appreciate that. I just happened just to take a look yesterday at my PayPal, and all of a sudden I was like, oh, there's a little bit of money in there. Thank you so much. Seeing as it's not out yet, I hope they add some snark after watching what happened since the oral arguments. She didn't. Yeah, I know. It just is shocking, isn't it? Okay, well, you know what? There's some paperwork definitely to go through here. I think this one was 9 pages, and one is, let me just check. I think the other one was 11. This is 9. Okay, so let's get into it. Motion to dismiss for destroying exculpatory evidence comes now. The accused, Richard Allen, by and through counsel, Andrew Baldwin, Rosie, and pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution. Article 1, Section 12 of the Indiana Constitution of Indiana Code, blah, moves this court to dismiss charges against the accused for destroying exculpatory evidence. Oh, and by the way, don't forget yesterday, of course, limited David Hennessy, of course, for Rosie and Baldwin, the limited appearance as well. Those 2 documents had come out, but that wasn't worthy of doing a live or anything like that. In violation of the standard, sets out the Brady versus Maryland. In support of said motion, the accused states the following: that Richard Allen stands accused of, do I want to start off this early already saying that word? Okay, fine. Murdering 2 victims on or about February 13, 2007. Since receiving discovery on this case, the defense has unearthed significant evidence that third parties named Brad Holder and Patrick Westfall were involved in the murders, really. Okay, that evidence is critical as to the theory of defense. So the defense would incorporate into the motion that the contents of the Frank's memorandum that was filed with this court on September 18th of 2023, which provides the details of evidence that supports Brad Holder's and Patrick Westfall's involvement in the murders. In discovery, the defense found a document dated February 17th, 2017, that appears to be an FBI report memorializing an interview of Brad Holder. Contained within the document are these words: the below is an interview summary. It is not intended to be verbatim account and does not memorialize all statements made during the interview. Communications by the parties in the interview room were electronically recorded. The recordings capture the actual words spoken, emphasis added. I like how they do that, emphasis added. Also, in discovery, the defense found a document dated February 19, 2017, that appears to memorialize an interview with Patrick Westfall. The report itself does not indicate whether the interview was recorded, although defense would expect that standard procedure would require video or audio recordings of all statements. After locating this document, the defense sought a copy of the recording detailed in the February 17, 2017 report so that defense could listen to the exact spoken words of Brad Holder during his interview. This is vital to Allen's defense, particularly the statements that the author of the document admits were not memorialized in the document. Also, the defense requests a copy of all audio video of Patrick Westfall's interview that was memorialized in a February 19, 2017 report. 8. On September 8, 2023, the prosecutor communicated in a letter that there were no audio or video interviews of Brad Holder or Patrick Westfall available. Prosecutor McClellan offered no explanation as to why these didn't exist. Before the defense had an opportunity to investigate the reason why these material pieces of evidence were not available, McClellan called for disqualifications of attorneys Rosie Baldwin as Richard Allen's lawyers. Judge Gull, without a great deal of hesitation, said she was leaning toward granting McClellan's request. Ultimately, Judge Gull caused Rosie and Baldwin to be taken off the case. This occurred before Baldwin and Rosie learned of why crucial videotaped interviews were missing. Ooh, that sounds like a conspiracy right there. Okay. On January 31st, 2024, after being reinstated to the case, the prosecution turned over discovery to the defense, including a letter cataloging the evidence that the prosecutor was turning over to the defense. 11. Contained on paragraph 5, page 5, paragraph 5 of the itemization of discovery are these words that explain Brad Holder's missing videotaped interview and Patrick Westfall's missing interview, if one existed. Due to a DVR program error discovered on the 9th of the 20th of 2017, all recordings up to February 20th, 2017 were recorded over. There is no detectable audio found on this drive. Remember, Brad Holder and Patrick Westphal were interviewed during this very short window, February 14th of 2017 to February 20th of 2017. Within the days of the murders, the videotaped interviews were deleted by police. It is unknown whether or what other interviews were deleted during the relevant time frames. The destruction of material interviews of key suspects early in the investigation demonstrates negligence, if not intentional conduct on part of the state. How could law enforcement, while investigating the most serious crimes, record over interviews of material suspects with recklessness or intentionality? Sorry. Um, as a material part of defense, Richard Allen is expected to direct the attention toward Brad Holder and Patrick Westphal as being involved in the murders of these two young victims. The evidence will also show that Richard Allen does not know Brad Holder or Patrick Westphal, and therefore that Richard Allen has nothing to do with the murders. This destroyed videotape interview of Holder and Patrick Westphal, if it ever existed, was expected to contain evidence that could provide exculpatory and material evidence in support of Richard Allen's defense. If a recording of Westphal was never secured, that too is a purposeful or negligent failure to preserve material and exculpatory evidence. 13. Experienced defense lawyers fully understand the significance of comparing and contrasting the accuracy and credibility of one's video and audio taped statement with that information which is represented by law enforcement officers in police reports or summaries. It is through this process that Richard Allen would have been able to challenge the veracity of the statement of Holder and Westphal. However, the state's intentional or negligent destruction of the original recordings deprived the accused of such an opportunity. The state's actions have deprived the defense of the ability to compare Brad Holder's words from February 17th of 2017, only 3 days after the victims were murdered, to the evidence that was unearthed over the next several weeks, months, and years. This would have allowed Richard Allen to determine whether Holder's story was consistent with unknown evidence at the time of Holder's first statement and whether it is consistent or inconsistent with the future testimony, be that trial testimony or deposition testimony or statements made to other person or witnesses. Um, 15. In any criminal investigation, the interviews of potential witnesses must be preserved, such as the precise words of Holder and Westphal in their 2017 interviews. Because as additional information is developed, reviewing prior statements may reveal inconsistencies or raise questions about other witnesses or other information relevant to an unbiased investigation. Without the actual audio or video that would provide the exact words spoken from Brad Holder's mouth, the accused Richard Allen will never ever be able to know exactly how many inconsistencies existed in the original statements of Brad Holder or Patrick Westphal when compared to the evidence that was later discovered or future testimony of Holder and Westphal, nor can Richard Allen challenge the credibility of Holder and Westphal in light of the subsequently discovered evidence. Furthermore, Allen is deprived of the ability to confront either suspect with their own words contradicting any self-serving testimony they may offer through the investigation or prosecution. On August 30th, 2023, following depositions in which the state of Indiana and law enforcement learned that the defense believed Brad Holder to be an actor in the murders, law enforcement finally re-interviewed Holder for what is believed to be the first time since 2017. While in 2017, according to the memorialized report, Brad Holder told law enforcement that he never met Abby Williams, who purportedly dating his son. His story changed in 2023 when he talked to law enforcement. In 2023, Holder told the interviewer that at 3909 mark, I barely even knew that girl. I met her once. Therefore, one material and highly relevant contradiction exists. It is therefore plausible that many more contradictions would be available to the defense, but for the state's intentional or negligent failure to preserve all of the evidence. Such negligent and intentional conduct on part of the police has also resulted in the absence of material evidence which would be exculpatory in nature. This circumstance in and of itself violates Richard Allen's due. Oh, hold on, little footnote. The 2017 report stated Holder never actually met Abby himself. Okay. Process rights. Process rights, yeah. We must, however, place such conduct in a greater and more noteworthy context. 21. It has also been discovered that former Rushville police officer Todd Click reached out to Prosecutor McClellan in an attempt to bring his attention the existence of an 85-page report summarizing the investigation that revolved around Brad Holder, Patrick Westfall, and other affiliates. This letter, which landed on Prosecutor McClellan's desk via certified mailing on May 1st of 2023, was not discovered to the defense until more than 4 months later, on September 8th of 2023, and only after the defense disclosed in depositions that they were aware of the odious ties to the crime scene and investigation. This failure to disclose on part of the prosecutor, if not entirely intentional, rises to the level of an untimely failure of disclosure of potentially exculpatory evidence. The failure to disclose sheds further suspicion on the absence of the Holder and Westfall interviews referenced herein. Furthermore, as explains in the Franks motion, it appears as if the law enforcement and possibly the prosecutor himself attempted to conceal the identity of a Purdue professor who contradicts the sworn words of Trooper Jerry Holman and Sheriff Tony Liggett concerning whether the crime scene contained signs of the involvement of an odious cult. In more recent discovery, the defense also located a prepared search warrant application to AT&T for data contained on Brad Holder and Patrick Westfall's mobile devices. Each application states that Holder/Westfall is a known member of a religious sect, and elements of the murder have potential religious significance. The former or the information being requested is relevant to the ongoing criminal investigation. There is no evidence that the warrant was ever served. Also, the defense has not located any discovery regarding any data contained on Holder's or Westfall's 2017 phones or any other electronic devices. It defies logic that law enforcement would conduct forensic examinations of so many other phones in its investigation, yet ignore the phones of Brad Holder and Patrick Westfall, who were viewed as suspect within 3 days of the murders and interviewed by law enforcement, who then prepared search warrants for those phones. These suspicious facts further call into question the circumstances surrounding the destruction of key videotape statements of Holder and Westfall, if it ever existed, and support Richard Allen's motion to dismiss all charge filed by the state of Indiana. Defendant requests a hearing at which time he can present evidence and make arguments as to why these charges should be dismissed. The defense files contemporaneously. That's a word in itself. That's like what, half of the alphabet right there. Anyways, here with the memorandum in support of this motion. Wherefore, Richard Allen, for all reasons cited herein and in the accompanying memorandum, moves to dismiss all charges against him and requests a hearing on his motion. Okay, so that's that one. Let me just go to chat here. Just going to see what you guys are saying. Love Hennessy. Without hearing, though. Oh, here, I'll just come off to the side for a second. Exactly. No hearing again. How convenient. What? Wait, all the interviews were deleted at that time. Deleted? Did they say that? Didn't they say that they were taped over? That's what this says, Steffa. What a total mess. Is there a footnote on that statement? Did I miss a footnote? Let me just take a look here. Did I miss any footnotes? We saw that one. I don't think I missed any footnotes besides that one. No, that was the only footnote on there. Let me just come back over again. That's a serious problem. What will be done about this is my question. What will be done, Steffa? How can the prosecutor have a case with all the interviews deleted? Okay, wait. Who shall be responsible for all these deleted interviews? Whoever that is. I can tell you this, no matter what happens, if he is found guilty, it will be overturned. Charmaine, I can't believe that this can go to trial after hearing this. How could anyone be held responsible for the girl's murders after this? Despicable. I agree. I got a footnote for someone. Okay, let me just quickly go back there. Should I delete it, or did it say? Because when I'm reading it, it's hard. It's harder to absorb it because I'm just trying to like read it and I'm trying to absorb it at the same time. But I thought it said that it was that they were went over, like recorded over, and then deleted or whatever. It's not intended verbatim. The report itself did not indicate that the video was recorded. Report itself does not indicate whether the interview was recorded, although the defense would expect. Okay, but where did it get to? Is that a copy of the recording? Boom, boom, boom. Prosecutor. Okay, so he didn't offer an explanation there. Turn over discovery of the defense. Just trying to find where that one part was. Itemizations were blah, blah, blah. Okay, missing interview. Wait. So contained on page 5, paragraph 5 of the itemization of discovery are these words that explain Brad Holder's missing videotaped interview and Patrick Westfall's missing interview. Oh, if one existed. Due to the DVR program error discovered, all recordings up until were recorded over. Is that the part that you guys are talking about right there? Okay, let me just go over here. What is it? Control F. Deleted. Two. Results found. All views were deleted by the people. The videotape interviews were deleted by the police. Okay, that's for you guys. If I just scroll down a little bit more, there's no detectable audio found on this drive. Remember, Brad Holder Westfall's interview during this short window. The murders of videotaped interviews were deleted by the police. It is unknown what other interviews were deleted during this relevant time frames. The destruction of material. Okay. Now, what was the other one? Oh, I guess it was right there. Same thing. Deleted on there. So, come back to you guys over there. Okay. Yeah, sometimes, like I said, it's hard when you're reading it, because like when I'm reading it by myself, then I can sit there and absorb it. But when I'm reading it to you guys, it's kind of like, it's like you get this kind of like this overview kind of thing, but you're not really absorbing it until you go back and read it again. Okay, so let me take this down, and then we'll go to the next one. Okay, and then we'll look at your guys' comments as well. Okay, so the memo. This is the memo. 1 second here. We'll see if we can do a little bit bigger. It's probably a little bit too big. Come on. You just got to touch this sucker. And then can I get it a little bit bigger? Without 192. That's good. So memorandum of law in support of the dismissal. And I believe this one is 11 pages. Okay, come on. Be nice to me. Share screen window. And this one. Okay. If you guys could give a like, if you guys won't mind. I'm just going to have one drink of water really quick, and I'll just be right back, okay? Just looking at your comments here for a second. Holy balls, for sure. Just when I thought nothing would surprise me in this case, wondered if PFD is working on a new original action. PFD, you guys, stands for Princess of Fucking Darkness, that Travis calls her. Hi, Sunny in chat. Steph, I agree wholeheartedly. Hi, Shane. How are you? Okay, so good morning, everyone. And 2 secs. Hey, Charmaine, I guess we can talk about it all tonight, huh? I guess we'll do a live tonight on Delphi. I was deciding what we were going to do. There's different things going on. Well, there's a few things going on to be, I don't know, but we'll do Delphi and discuss it more. Anyways, so let me go to this one, you guys, and then we'll, like I said, come back. This one's 11 pages. So memorandum of law in support of the dismissal. At the issue, it is the purposeful or negligent failure to preserve and or destruction of material and exculpatory evidence critical to defense of Mr. Allen. It also involves the attempted concealment of the identity of a key witness, later identified as Professor Jeffrey Turcott, and other exculpatory evidence such as Todd Click letter, and evidence referred to by Click in his letter. Indiana Code that states that this court may, upon motion of the defendants, dismiss an information upon certain grounds. In this case, the defendant requests that the court dismiss this information pursuant to Indiana Code, well, we'll just say it once, 35-4-1-4A11, which states that a motion to dismiss any information may be granted for any other ground that is basis for dismissal as a matter of law. Such grounds would include a violation of the defendant's constitutional right to due process. Additionally, trial courts have inherent authority to dismiss criminal charges where the prosecution of such charges would violate a defendant's constitutional rights is merely legislative recognition of this authority. Matlock versus State. Let's see, Indiana, 2008. Such grounds would include a violation of the defendant's constitutional right to due process. Or do we say process, Charmaine? Process or process? I can't remember which one it is now. Ricky's is having an event, 40% off sale. Okay. This Indiana Supreme Court has held that a serious breach of duty occurs when the prosecution willfully or intentionally, when unjustified by a public policy, obstructs the access of the defense to material evidence in its possession. Turnpaw versus State, Indiana, 1988. It is likewise a serious breach when, through lack of vigilance, the negligent destruction or withholding of material evidence by law enforcement officers or the prosecutor occurs. In such instances, grounds for reversal may exist. The Indiana Supreme Court has held that the negligent or intentional destruction of evidence by the police can provide grounds for reversal or dismissal on due process and due course of law grounds. See Berkeley versus State. Okay, all these cases here. Prior to any request for discovery by defendant, the negligent destruction or withholding of material evidence by the police or the prosecution may present grounds for reversal. Berkeley versus Hale, or Hale versus State. The Supreme Court has further held that when the prosecution determines evidence, okay, 1 second, turn off my phone. It always dings twice on a notification. That's why I usually turn it off and don't know when people sometimes message me. When the prosecution determines evidence to be non-material and further decides not to advise defense counsel of such evidence prior to its destruction, a heavy burden rests upon the prosecution to demonstrate that the destruction of the evidence did not prejudice the defendant. The appropriate test to apply when deciding whether defendants' due process rights have been violated by the state's failure to preserve evidence depends on whether the evidence in question was potentially useful evidence or material exculpatory evidence. Oh, Blanchard. That's my mom's last name. That's my last name. Yeah, I wonder if that person's related to that. What is it? Rose? What's that girl's name that's out there? Rose Blanchard or something like that. Anyways, the burden is on the state to demonstrate that this evidence was not material and its destruction did not prejudice the defendant. Cox versus State. 1981, potentially useful evidence is defined as evidentiary material of which no more can be said than it could have been subjected to tests as a result, which might have exonerated the defendant. The state's failure to preserve potentially useful evidence constitutes a due process violation when the defendant can show bad faith. The Seventh Circuit has held that bad faith may be inferred when a party disposes of evidence in violation of its own policies. Then those cases, violation of a record retention regulation creates a presumption that the missing records contained evidence adverse to the violator. That bad faith presumption arises when the failure to retain records or other evidence actually violates the terms of the applicable policies. However, the Indiana Court of Appeals has noted that in some instances, the destruction or failure to preserve evidence may be prejudicial to the defendant as to warrant reversal, even in the absence of bad faith by officers. Material exculpatory evidence, and on the other hand, is defined as evidence that possessed an exculpatory value that was apparent before the evidence was destroyed and is of such nature that the defendant would have been unable to obtain comparable evidence by other reasonably available means. The state's good or bad faith in failing to preserve material exculpatory evidence is irrelevant. The Indiana Supreme Court has held that the defendant must establish materiality as a condition precedent to claiming a denial of due process where evidence is negligently lost or withheld by the government, except where the materiality, what a word, is self-evident or the showing, oh my God, again, materiality, okay, is prevented by the destruction of the evidence. As an item is material, if it appears that it might benefit the preparation of the defendant's case, or if it might reasonably affect the outcome of the trial. In this matter, given the nature of the evidence, the law enforcement either failed to preserve or actually destroyed the materiality, and it's self-evident. Furthermore, as in Lee, the failure to preserve the destruction prevents the defense from establishing the exculpatory nature of the evidence and its materiality. Okay. As such, Ellen is not required to demonstrate the, oh my God, how many times do they got to say this word? Materiality of the evidence. To be sure, the unavailable evidence has exculpatory value, which was apparent at the time it should have been preserved and prior to its destruction. Additionally, Allen is unable to obtain comparable evidence by other reasonable means. See Blanchard. Spoliation, there's a word, of evidence is the intentional destruction, mutilation, alteration, and concealment of evidence. If spoliation by a party to the lawsuit is proved, rules of evidence permit the jury to infer that the missing evidence was unfavorable to the party. Even if the court requires the showing of bad faith, it is apparent. Bad faith is defined as being not simply bad judgment or negligence, but rather implies the conscious doing or wrong because of dishonest purpose or moral obliquity, whatever. Okay. Deviation from moral rectitude. I'm learning a whole bunch of new words today, it seems like. Or sound thinking. Well, I know that it's more like lawyer words that they use. The United States, court words. The United States Supreme Court has recognized that the police have constitutional duty to preserve such evidence. In Trombetta, the Supreme Court observed that whatever duty the Constitution imposes on the states to preserve evidence, that duty must be limited to the evidence that they may have expected to play a significant role in the suspect's defense. California versus Trombetta. The court recognized that the duty in Arizona versus Youngblood, confirming that the Constitution imposes at least a limited obligation on the police to preserve evidence that could form the basis of exonerating the defendant. It is beyond debatable that the evidence at the issue here would play a significant role in Mr. Allen's defense and would form a basis for exonerating him. Additionally, the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of good faith of the prosecution. So to prevail on a Brady claim, a defendant must establish that the prosecution suppressed evidence, 2, that the evidence was favorable to the defense, and 3, that the evidence was material to an issue at trial. It is clear that the federal Constitution is not the sole guarantor of the right to due process and other rights. Chief Justice Shepard made this abundantly clear in his law review article, Second Wind from the Indiana Bill of Rights, 22 Indiana, 1989, when he stated in conclusion that civil liberties protected only by the U.S. Supreme Court are only as secure as the Warren Court or the Rehnquist Court wishes to make them. The protection of Americans against tyranny requires that the Supreme Courts and state constitutions be strong centers of authority on rights of the people. I am determined that the Indiana Constitution and the Indiana Supreme Court be strong protectors of those rights. The Chief Justice also stated that Indiana was an early and noteworthy participant in using its Bill of Rights to defend personal liberty. After citing the numerous early decisions noted, these were but a few in a fine line of cases in which Indiana Supreme Court held the Indiana Bill of Rights afforded Hoosiers, Hoosiers, right, for which the federal Constitution did not. Chief Justice Shepard also made note of the fact that many provisions of the Indiana Bill of Rights have no counterparts in the United States Constitution, and observed that Article 1, Section 12 was one of those provisions. This provision relating to due process is an issue in this instant case. The Due Process Clause of the United States Constitution is found in Section 1 of the 14th Amendment of to the Constitution. That section states in relevant part that the state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any personal life, liberty, or property without due process of the law. Hold on. Wait for it. Emphasis added. Okay, there we go. The right to due process conferred that the Constitution of the State of Indiana was found in Article 1, Section 12, and contains significant language not found in the Constitution of the United States. The provision states, all courts shall be open for every person for injury done to him in his person, property, or reputation shall have remedy by due course of the law. Justice shall be administered freely and without purchase, completely, without denial, speedily, and without delay. Emphasis added. While the defense is unaware of any Indiana case law specifically interpreting the emphasized portion of this constitutional provision, the provision itself was traced back to the Magna Charta versus State ex-rel Board of County, in 1911. The Larimore Court was acknowledged that although the provisions were derived from the Magna Charta, it may be a broader guarantee. Of free, unpurchased, and impartial justice. Three more contemporary decisions dealing with the issue of destruction of evidence are of particular import. First, it is clear from the Chief of Justice Shepard's concurrence in the House versus State that the issue of whether a lack of good faith on the part of the state was required and a defendant to obtain a remedy for destruction of potential exculpatory evidence under the Indiana Constitution has not been decided adversely to the defendant, even after Youngblood. The House decision actually dealt with the discovery and potential exculpatory evidence and the need for materiality of that evidence. Both Chief Justice Shepard and Chief DeBruler, however, discussed that related issue destruction or loss of such evidence. In his concurrence and dissent, Justice DeBruler stated that, while I agree with the result reached by the majority opinion in this discovery issue, I point out that when the accused shows that material evidence was in the hands of the prosecution and lost, the question of whether the accused must go ahead and show prejudice is open in Indiana. In my judgment, when the item is not available for scrutiny by the trial court, but is known to have been material, the risk of loss should be borne by the prosecution, not the defendant. The police and prosecutors are, after all, highly trained specialists in the gathering and retention of evidence and should be expected to be carefully retain. Well, you would think so, right? To carefully retain all material evidence in usable form. Chief Justice Shepard, in his concurrence, stated that I agree that Justice DeBruler that this case does not decide what Indiana should use for cases in which the prosecution has disposed arguably material evidence which might exculpate a defendant. The instant case certainty appears to be the type envisioned by the comments, 2 Indiana decisions have been found in which the issue of due process and destruction of evidence was raised under both federal and Indiana constitutions. Then they have the courts there. Well, whatever. Hale versus State and Douglas versus State. Although both of these decisions were determined adversely to the defendants based on the facts of the cases, but also stated that the negligent or intentional destruction of material evidence by the police or the prosecution may present grounds for reversal. Each case, the defense alleged a violation of due process underneath both federal and state constitutions. While both decisions were rendered prior to the United States Supreme Court decision in Youngblood, supra the decision in the House rendered that after Youngblood decision makes it clear that the principle announced that in Hale versus and Douglas, may still be valid under the Indiana Constitution. Additionally, Lee supra was decided after Youngblood. If the language of Article 1, Section 12 of the Indiana Constitution, justice shall be administered freely and without prejudice, completely and without denial, speedily and without delay. It is to have any meaning at all. Is to have any meaning at all. It certainly seems to support a more stringent enforcement of due process rights that required under federal constitution. Given the facts of the instant case, the penalty involved, and the long history of the concern about preservation of evidence in Indiana case law, as well as the evidence of attempts of law enforcement and the state of Indiana attempting to conceal other material and exculpatory evidence, Mr. Allen should not be deprived of a remedy for the egregious loss of evidence occasioned by the actions of law enforcement and the prosecution in this case, especially in light of the ease to which the evidence could have been preserved. Okay, that's where Adam got that. Conclusion. The only remedy that serves the interest of justice and guarantees Mr. Allen's constitutional rights is dismissal. By Baldwin, Rosie. On there. Okay. There we go. Now I can come back. See what you guys are all saying. Morning, Sleuthy. We need to add Chat GPT explanation to these shows. I had the Chat GPT, but I hated paying $10 a week. kind of like that thing, actually, to be honest. Memo, maybe Ivy. Not sure though. That whole last one obviously was, basically about the destruction of the exculpatory evidence that they said, but in the first one they kept saying if it was ever recorded, but then it said that what was it, and that they were deleted. I mean, it's not a shocker there, is it? Right? I can't believe she cited the Supreme Court without the opinion coming out. What if? Well, I know. I'm like, why isn't that thing out yet? Right? So much. Like, what does promptly mean in in the Supreme Court? I would think that promptly meant that was going to come out within like the next week, basically. If the families weren't paying attention before, they better now. The state and the judge had made a bigger mess, and you can't undo this. Little gambler. Wow. It's a motion to dismiss the case for the prosecution destroying the evidence. Separate memo supporting it. Yeah, exactly. Simple as that, really. Between law and I agree. I know you mentioned the interior strumming, but I'm just now putting it all together. Oh, okay. Yes, I did the memo, I believe. The 11 a.m. client canceled on me this morning. The Delphi gods knew. That's cute. Hold on to your butt, Ivy. It's wild. Let's see. This is crazy. Can we just get a do-over? And Judge Diener stay? Right. He'd probably go instant retirement. Conclusion, corruption. Oh, using spell check on that there, little gambler? I don't pay for it. You talking about Chat GPT? No pun intended. I honestly think the defense lawyers are filing motions just to stall. That usually means that their client is guilty and they know it. Well, I mean, remember, they were just handed over a bunch of new evidence. Uh, I don't have enough swear words for all of this. I'm sure you do. How could anyone be held responsible after this information about the interviews being deleted? This is huge. Steffa, what are you going to go do about it? I think you should go down there right now and go and talk to, who do you want to talk to? Carter? I demand that you go down there. You do boots on the ground, okay? Steffa, I got a few minutes here ago, and I'm still trying to figure out everything going on. What exactly is being alleged to happen to the evidence? That it was destroyed, purposely or not purposely, type of thing. Either way, that it was. Go back over. I'll go back over to that one in a sec here. IV Mustang. This seems to be more than stalling. Love to hunt. Interviews deleted. Sorry, because they aren't related to the case, not related to the prosecution case, but to the defense's case. They can claim anything in the motions. Doesn't make it true. Well, it can't be a full out lie. Anyways, let's go. I'm gonna go back to let's see, stop screen for a second. Present. Let me go back to the other one. Hold on. The motion. Okay, on the right one. Oh, how do I get that back in there? Oh, there we go. Okay, hold on a second here. Share screen. Present share screen window. Okay, boom. Okay. One sec there. Okay, let me scroll back up. So where were we here? Okay, so number 11, contained on page 5, paragraph 5 of the itemization of discovery are these words that explain Brad Holder's missing videotaped interview and Patrick Westfall's missing interview, if one existed, due to a DVR program error discovered on the 9th of the 20th of 2017. All recordings up until February 20th of 2017 were recorded over. So due to a DVR program error discovered on the 9th, so it's like August 20th of 2017, all recordings up into February 20th, 2017 were recorded over. There's no detectable audio found on this drive. Remember, Brad Holder, Patrick Westfall were interviewed during this very short window from February 14th, 2017 to February 20th of 2017, within days of the murders. The videotaped interviews were deleted by police. It is unknown what other interviews were deleted during the relevant time frames. The destruction of material interviews of key suspects early in the investigation demonstrates negligence, if not intentional conduct, on part of the state. How could law enforcement, while investigating the most serious of crimes, record over interviews of material suspects with recklessness or intentionality? Well, because it's Delphi. Okay, we're talking Carroll County in that here. Come on now. That wouldn't be a shocker. Like, seriously. Hi, True Guy. Hey, gonna be a busy Delphi day, I think. Yeah, we'll see if anything else comes out today. Maybe we'll get the court of opinion all of a sudden pop up. Each move closer to checkmate. Yeah, but nothing about this whole case should have been deleted or recorded over. Yet another hot mess. Mark, thinking the same. It doesn't matter if they were dismissed. The allegations have been made. Seeing if I missed anything up here. I feel this will I think so as well, Sleuthy, to be honest with you. I bet that these motions will be dismissed too. Yeah, emotions are part of the trial process. They can't lie to stall. Well, exactly. Um, if we immediately decide the defense in a case is lying about stuff just like this, then how will we ever know when it's legit? That's something we would want to know and care about. Things like this happening. In a case is lying about stuff like this, yeah. My brain is blown right now. Ivy, you joining the live tonight? I just don't think people realize how big this is. I don't know how prosecution can recover. Someone tell me how prosecution can come back after this before I have a panic attack. They're there, Stefan. They're there. Um, mm, right. They can't claim anything. They're literally swearing under oath when they are filing things. But wasn't the evidence deleted by law enforcement? That's what it said. Um, they can't put right lie. What evidence? All interviews prior. What evidence? All interviews prior to the 20th. Wait, the 20th of the 2nd? That was the 9th of the 20th, eh? There was the 9th of the 20th. And if they didn't file motions about it, you people would crucify them for being ineffective. So no matter what they do, they'll always be wrong. They can claim anything in the motions doesn't make it true. Oh, we already went there. Okay. Let me scroll back down on there. Elizabeth, I'm not sure, but there's no way she'll just dismiss the case. No. Did you already read the denial of recusal? Yeah, AJ, that was like a couple sentences you're talking about, like at the start. So for anyone, I guess, coming in, order issued, I think you're talking about here. Stop screen, present, share screen. I literally had my husband just went off to work and all of a sudden, pop, 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 all these emotions coming. You talk about this one, AJ? Can you see it on screen there? The court now has defendants verified. Motion to disqualify, of course. What was she going to do? Go, you know what? Yeah, I think I'll just disqualify myself. Yeah, why not? Isn't that so weird? Doesn't it seem so strange when a motion comes out and then the judge that's being asked is the one that gets to reply? That seems so strange to me. Oops, on there. Ivy, you busy now? Did you want to pop on, Ivy? Feel free, or Steffa and Ivy. Anyone want to pop on? Anybody? Anybody can feel free to pop on. I should put my border back on, I suppose. I always feel naked now without it. Anyways, if anyone wants to pop on, feel free, let me know. Me personally, nothing shocks me. I just keep seeing what keeps coming in, and then knowing that it's going to keep going on for whatever. I mean, it would be nice if the opinion would come down, that's for sure. The same malfunction of the marathon gas station tapes. Thoughts? Yeah, well, I mean, we heard that from Murder Sheets about that. Okay, okay. Yeah, no biggie. I'm just asking. Because if not, we're going to be going on tonight and we can talk about, we can all have our opinions then if you want. So it's up to you. Steffa, are you good? You want to come on? Are you working or whatever? I was truly thinking I was just going to sleep in this morning a little bit. It was like, I was actually debating if I was going to do the Montgomery. I don't usually do trials, right? I did the yesterday the Jennifer Crumbly one, but the Harmony Montgomery one, of course, starts today. Sad. I'm feeling another original action in the making. And yes, if anyone doesn't know how bad this is, bad isn't a big enough word. Well, true. Or it's not exactly shocking to me though. I mean, nothing I don't think is shocking. I would think that nothing's really shocking to people in Delphi. I mean, really, it's not. Expect the unexpected. I came in on the last few minutes of reading, so I'll need to read them myself. Yeah, did somebody put them in chat? If not, I will. Did Adam put them in chat, do you know? All they're doing is pissy fighting each other and absolutely no we're doing any justice for the girls. Well, you know what? I would just really like GP and morning GP. I'd really just like for the opinion to come out. And because remember, like I said, that they were gonna let us know how they came to the conclusion that they did. Where is Aspen? Do you think? I think he's being a hairdresser today. I don't think he's babysitting. I think it's kind of like he is a hairdresser, then he's babysitting, hairdresser, babysitting. Do they think, we think that there will be yeah, I believe we were just talking about that yesterday or whatever it was, or the day before. Does the defense have any possible recourse after her denial? Um, does the defense have any possible recourse after her denial? What, to dismiss herself? You mean this? You mean to disqualify herself? I mean, there's going to be a shitload more motions, like a shitload. Justice is convicting the right person. Yeah, absolutely. When is the start of this trial? Yeah, well, as if it's going to happen in 2024. Anyways, it's October something, I believe it is. October, I want to say 24th or something like that. I just don't I just don't listen to dates anymore really because they usually always change. So it's like I believe it when I see it because especially with Delphi. Everyone who failed Harmony her whole young life will be held accountable. Yeah, that's very sad. AJ and interlocutor appeal, but I see. I don't want to like speak out of turn because I'm not an almost lawyer, like Aspid is and stuff like that. Um, I don't know your guys' laws over there, or even to be honest, um, I can understand the verbatim of it, but to sit there and give any, actual knowledgeable statements and stuff like that, nah, lawyer stuff and over my head. AJ an interlocutory appeal, but I think she has to grant it. Um, my response was, and they're gonna be, oh, yeah, oh, yeah. I wonder if there's any more coming out today. I would just like the court of opinion to come out, right? Like, let's just see what that has to say. She can deny an interlocutory appeal. Absolutely. It seems so weird, you know? Yeah. The defense is trying to get Richard Allen off on technicality. Well, that's just a given, though, right? Like, I mean, oh, by the way, um, I don't know what some of you guys thought because I was streaming it from Law and Crime Network or whatever, but you know, just asking anyone that watched that yesterday, just one, if you think that she should have been convicted, meaning Jennifer Crumbly, or two, if you think that she shouldn't have. Simple as that, really. You know, mm. That's a hard one, but now it's like a precedent for sure. You know, it's just be a matter of what other cases will come up in the future of what they consider gross negligence in a sense and foreseeability. Look, Gull is moving up to the Supreme Court and won't disqualify herself. She is doing her job. I think she's going to deny all. She pretty much does, doesn't she? Yeah. Prosecution approved. Defense denied. It sounds like that's a weird thing. Indiana thing. I mean, it's hard. It's after watching what we did with the Supreme Court, and stuff like that, and then Rosie and Baldwin come back on, who else isn't feeling a little bit kind of, I don't want to use the word awkward, but every time you see emotion that's denied by Fran Gull now, you're just like, oh yeah, she's just doing a piss take. Now she's just doing a piss take. Deny, 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 deny. Because you can't help now but think that there's like that it's weird, you know. I know that business is business and stuff like that, in a sense, but it's so strange, you know um, gross negligence. Oh, hi, Franco. We're back. You know, you fucked up. I think she will too, Charmaine. She will find herself back in front of the. I. That's kind of what I feel. I feel like it's. I feel like we're going to see ourselves back in front of the Supreme Court here again. Um, Mark, if it's true that exculpatory evidence was deleted, would that be a technicality? Yeah. See, I don't know how all that part works out. you know I mean, obviously there's in these motions, it's basically like saying, look, if they basically were negligent and purposely or unintentionally deleted exculpatory evidence, like this is grounds for basically dismissal. Mm. um because it's not like that wouldn't be huge. Of course that's huge, right? I mean, Delphi has been, to me personally, nothing but a bunch of fuck ups and fucktards, right from the shit show of this, the whole of calling off the dogs, not taking sticks, just everything. And to me, Carter can keep trying to shine shit up everyone's asses with his words and stuff like that. And I love you, Carter. I love your heart. You are passionate, but you're so fucking double talking, and it's like I said, there was, to me, like so many. This is, I'm speaking from my opinion, by the way. It can be yours as well or not. But I'm just saying, to me, there's been so many fuck ups with this case. Like, honestly, I mean, I think that it feels like there's this mound of evidence that they can basically show that, hey, look, this wasn't done properly. This wasn't done properly. This wasn't done properly. This was, you know, and that's kind of where it's kind of like I always think of this case and I'm like, oh, like without the shit, to me, you can see where reasonable doubt would come to a juror, because of, I don't know, that's how I keep feeling. Um, but I'm just waiting for the process to happen. We can read all these things and watch it all play out and get pissed and laugh about it, some of them sometimes, because it just seems like it's just, oh my god, here's some more. But at some point it will play out. Could be 2020, I guess. 20 no 2030. We've already done 2020. Ivy, wouldn't that be a fatal error or structural error? Even a 15-year-old doesn't ever need a handgun. Well, I don't. Yeah, like I said, I'm not going to get into your guys' gun laws. That's just a whole different ball of wax topic over there. Do I think? I mean, like I said, it's just totally different from Canada. Like I said, you guys have your amendments there. We have our way of doing stuff here. I have my personal thoughts on all that stuff, but it's not worthy of people getting into arguments over it, and that's always what happens, whether it's politics or stuff like that. Heck, you can't even talk about the Texas borders without people getting their panties in a pinch on that. Um, I just can talk about whatever, and I could care less. Whatever the topic is, for me, I could care less. If we have a conversation, I can talk like a regular adult and have a conversation, and but a lot of people can't. So Ivy wouldn't be that fit. Oh, we already read that one. No, it would be at Ivy Rose. We shouldn't accept behavior like that from investigators or prosecutors ever. Um, oh, you're a YouTube lawyer? Yeah? Did you go all the way to Google to print one off? Or just to, when are they claiming these interviews were deleted? Um, well, they basically, it's, okay, hold on. Let me take that back down again. Oh, stop screen. Let's go to that back. Unless somebody answered you by this point already. Present. Hold on. I'm gonna find my file. I'll just go back to it. Present, share screen. I still was playing with freaking OBS yesterday at StreamYards because I'm kind of sick of all this shit. One downfall about Streamlabs, one huge downfall, although a monkey can use StreamYard, um, I hate the fact that they only have one media spot. At least with OBS, you can literally put different media up on there and stuff like that. Plus, you can have the fun freaking, donation membership subscriber things go off where I can create my own emojis that go off and stuff like that. It is a lot funner. I just keep pushing it off to the side for a long time, to be honest with you. Um, but I'm really getting sick of this whole um, like unless you have two computers where you drag it over. But I just really hate that StreamYard, just hasn't advanced. Advance your asses, StreamYard, because it's really irritating only having one video capture instead of like at least two. At least two. That's just me venting as a creator. Okay. When are they? Okay. So when are they? Well, let's see here. Patrick Falls missing interview are discovered on the 9th. So, I mean, they're saying that the program error discovered on the 20th of the 9th and all recordings up to February 20th. That's on January 31st, 2024, after being reinstated, to the prosecution turned over the discovery. I mean, so whenever they turn this over, I guess it sounds like, then they were able to see the information. Is that what I'm taking from this? On September 8th, the prosecutor communicated in a letter that there was no audio or video interviews of Brad Holder. Okay, so on September 8th, and the defense requested a copy of all. Okay. Yeah. The rest of these dates are just to do with the requesting and interviews. I don't know if that answered your question there, Ivy. Whoops. I forgot where I was here. I feel like that would make a big. Okay, no, I'm kind of lost at that. Sunny said nothing would surprise me in Delphi case. Yeah, well, it just doesn't. Like nothing. Like literally nothing. The only thing that would surprise me is if somebody literally goes, "Yeah, I did it. I'm guilty, and this is why." That would surprise me. That'd be a good surprise. Top of this memo at Ivy. So approve the hearing for motion, dismiss, and hold it. Okay, wait, just to ask you guys, is it moving forward on the 12th? I'm all confused with dates now. So approve the hearing for motion, dismiss, and hold it. I don't know. Oops, I hear sirens. Denying is one thing, but not even having a hearing about it is another. Technicality is something people say when the prosecution fails to follow proper procedure and such to convict someone. It's their job to get a conviction, not the defense. Soon as Toby called off the dog, Seward. Yeah, I mean, I don't like Tobe Lesenby. I can't stand the dude. Honestly, I can't stand to look at his face, his gum smacking cheeks. Tell it like it is. Hi, spinster. Spinster, you get it? You a spinster like Charmaine? Thank you. It's close. Yes, it was close. Thank you. The program error was discovered right, allegedly. I said dumb fuckery needs to stop. Dad's going to stop in this case. The idea it was intentional is absurd. Well, I mean, they got to put it in there, right? I mean, in all fairness, to put that error. At the end of the day, yeah, like for me, I always remember the defense has a job to do, the prosecution has a job to do, or not to do, one of the two. But this is beyond dumb. This is deeply concerning. Let's just go back to what Charmaine said. The minute Tobe Lesenby called off the dogs, it went to shit take, to be honest with you. Like just everything, right? Oh, the file. Where's Ari's file under Whitman? Underneath Richard Whitman type of thing. Like just the whole thing Watching back before a shit show began from beginning, literally. I don't even know. Was there an interview with what was it, Doolin or whatever, and Richard Allen? Like, or was that just jotted down on paper? We don't allow kids to legally own guns. Right, the parent buys it for them type of idea. And RA and KK are completely lining up court dates, and the PCA now time to come up with timeline and my information or my opinion. Squeaky Will. Hi, Squeaky Will. So Baldwin and Rosie raked Gull over the coals in their last motion. All of that deep thinking case long complaining boils down to one word: denied. Yeah, I do, little gambler. It's just sad and sketchy as fuck. Forget. Charmaine, don't give them any ideas. Good morning. Good morning, CJK. What time is it? 8:19. 8:19 in my world. I'm not sure where you guys are all from, but most times I think of East Coast because it's 3 hours difference over there. So it's like 11, 8 to 9, yeah, 11:19 over there. No one listens to me, Mustang. Yeah. Who's Charmaine? Charmaine, what are you saying? If they were allegedly deleted way back in the beginning of the case, it would be a lot different than if they were alleging that they were deleted since September of 2022. Wild Man's Mom. Oh, Wild Man's Mom. I think that's my mother-in-law you're speaking of there. My question is, what do you hunt with a 9 mil pew pew? My answer is, oh, you're talking about the Jennifer Crumbly? One of my chopped liver G's. An interviews from 2000, not sure when deleted though. Will we ever know? Interviews from 2000. Well, right. I guess exactly. So it just really depends, because like when I worked at the hotel and we had our our cameras up and stuff like that, like every 7 days, if you didn't grab it, it records over it. And that's what it seems like they're saying there, was that they got recorded over. So like I said, so a lot of times cameras are like 7 days, typically was one of the longer times, to be honest with you. But back in 2017, I don't know. But where did it say that? I think it was unearthed. You know what? My favorite part of these motions, I think, is when he says emphasis added. I look forward to those. Emphasis added. Richard Allen stands accused of murdering 2 victims and are both February 13th. The defense would incorporate. Defense found a document dated February that appears to be an FBI. Okay, so just to reminder on this one, in the discovery, the defense found a document dated February 17th, 2017, that appears to be an FBI report memorializing an interview of Brad Holder. Contained within this document are these words: the below is an interview summary. It is not intended to be verbatim account. It does not memorialize all statements made during the interview. Communications by both parties in the interview room were electronically recorded. The recording captures the actual words spoken. Spoken. There we go. Ready? Emphasis added. There we go. Also, I'm just kind of reading this for anyone that's coming in. Also, the discovery, the defense found a document dated February 19, 2017, that appears to memorialize an interview of Patrick Westphal. The report itself does not indicate whether the interview was recorded, although the defense would expect that the standard procedure would require video or audio recordings of all statements. Okay, so the report itself does not indicate whether the interview was recorded, although the defense would expect that standard procedure would require video or audio recording of all statements. After locating this document, the defense sought a copy of the recording detailed in the February 2017 report, so the defense could listen to the exact spoken words of Brad Holder during his interview. That it is vital to Allen's defense particularly the statements that the author of the documents admits were not memorialized in the document. Also, whenever I see this word memorialized, I mean, instantly it's taking me to a gravestone head. Um, Also, the defense requested a copy of all audio video of Patrick Westfall's interview that was memorialized in February 19th of 2017. On September 8th in 2023, I think the prosecutor communicated in a letter that there was no audio or video interviews of Brad Holder or Patrick Westfall available. Prosecutor McClellan offered no explanation as to why these didn't exist. So my brain needs to think about something for a sec. So they're saying that they don't know if there was any audio or video, but proper procedure would dictate that there should be. And then contained on paragraph 5, page 5, paragraph 5 of the itemization of discovery are these words that explain Brad Holder's missing videotaped interview. Okay, so for people that are just coming in and stuff like that. So contained on page 5, paragraph 5 of the itemization of discovery are these words that explain Brad Holder's missing videotaped interview and Patrick Westfall's missing interview, if one existed. See, there's those words again, if one existed. Contained on page 5, paragraph 5, an itemized discovery of these words that explain Brad Holder's missing videotape interviews and Patrick Westfall's missing interview, if one existed, due to a DVR program error discovered on the 9th, August 20th of 2017. All recordings up to February 20th were recorded over. There is no detectable audio found in this drive. So, I mean, really, it's saying if there was even one recorded, and if they were recorded while they were taped over, and then the video, so let's just finish this off. Within the days of the murders, the videotaped interviews were deleted by the police. It is unknown whether other interviews were deleted. So let me get this straight in my head, and I'm just going to go right down to the bottom of the comments now because I'm sitting on there. Okay. When I'm reading that, what I'm taking it as, they don't know if there was audio or video taken, but the proper procedure would be, but how would they know? Because it's saying that the DVR recorded over, and then these interviews were deleted, but yet they don't still know, right? Am I reading that right way? But they don't know still truly if there was actual interviews of audio or video recorded. Is that it? Am I saying that right? Because that's what I feel like I'm reading from the top. Does that sound about right? Well, yeah, but they keep it, but Rosie and Baldwin and that they keep saying that if one even existed, they don't even know if a recording or audio existed, but by protocol, one or both should exist, of course. And then when you go down, it's basically saying that, all of the recordings from this date, whatever, to, well, whatever it said there, and then August 9th, 20th, all recordings up until February were recorded over. But that's still not knowing to me if there was actually recordings or if they fucked that up too. Oh, let's see. I want to see what Susie's saying there. Right. Protocol is to record interviews. The FBI wrote communications by the parties in the interview room were electronically. Okay. The recording captures the actual words spoken. Gotcha. So the FBI wrote communications by the parties in the interview room were electronically recorded. The recording captures the actual words spoken. Okay. It's just it's kind of like twisting my brain a little bit. So I'm like, well, how would they know if they don't know if one existed? Mm. Well, you would think. You would think. Um, no, don't want to. Gull would rather walk around with a broken glass than let Baldwin and Rosie win this battle. In the February 12th hearing, still ago. Yeah, is uh, sorry, because it's really hard to kind of look at this and be on a different screen and then come back. Could this be the origin of the lost gas station tape story? It could be, Ivy. You're right. It could be. Read number 4. In the discovery, the defense found a document dated February 17, 2017, that appears to be an FBI report that memorializing an interview of Brad Holder. Contained within the document are these words: the below is an interview summary. It is not intended to be verbatim and does not memorialize all statements made during the interview. Communications by the parties in the interview room were electronically recorded. The recording captures the actual words spoken, emphasis added. Also in the discovery, the defense found a document. You know what? I have to look up the stupid word memorialized for what they mean it in this. I kind of feel I know what it means. Memorialized. Memorialized. Um, okay. Legal definition. To create a written record of a meeting or oh, okay. Okay. I mean, it's just that it's such a weird word to me. I don't know why, but I just keep thinking of a gravestone every time I hear it. Right. They wrote the summary down as they remembered it. No, it wasn't in memory of. And the missing audio of Alan's statement to Doolin. Well, again, was there? Again, was there, or was it just jotted on a piece of paper? Recorded, saved for future reference. Yeah, I mean, yeah, just every time I read it, I'm just like, it just, it sounds like a funeral thing. Memorialized. Yeah. It just seems like an odd word to save and preserve. I don't know. It just seems like an odd word to me. So you want some read 5 as well. That's why they use the word, if that are confusing you. Did I just read 5? Oh yeah, this one right here. Also in the discovery, defense found the document. The report itself did not indicate whether the interview was recorded, although the defense would expect the standard procedure would require a video. Yeah. I mean, and you would think, I don't know, Delphi. Delphi. That's all I got to say about that. That's what makes it me think when they use it. Streamlabs done. Thanks for reminding me. Did you put your DNA on there? Freeze? If you guys could. I don't know. Dylan doesn't remember if he recorded his interview with her. Me, Jade. Okay. Kate, did Charmaine, do you want to come on, or are we just going to talk about the stuff all tonight when we all have like when we're all here? So will the judge dismiss the state for negligence? Sleuthy, if you want to come on right now and say anything, go ahead. Your brains are a lot better than mine when it comes to this shit. I did it. Was fun to hit the like. I like how YouTube, if you say like or subscribe in a video and it's about 3 minutes, it literally lights up like a little bit of a rainbow, and like you get the little splashy things coming on there. I'm good with tonight. Yeah. Charmaine, your beautiful emphasis added. Yeah, you flirt. Shut it. Yeah. I'm the only one that's allowed to flirt with Charmaine, Mark. Stop. We can say Delphi. We can surely say incompetence. Yeah, I believe so. Absolutely. I'm good with tonight. I'm good with tonight too. Um, yeah. Did Bob? Is he probably watching a trial or something like that? Bob Motta, Charmaine. I haven't looked. Are they like covering a trial right now? Defense diaries. Defense diaries. I think they're live, aren't they? Or maybe not. Live? Are they live? No, they aren't live. Okay. Crumbly trial live. That was yesterday. That was definitely nail biter. Oh no, Bob is very much aware. Yeah, I know he's aware, but at least again, let's test all the claims in this court. Keep looking for a live with Bob. Didn't see anything. Yeah, well, you got stuck with me, Elizabeth. Has anyone looked in the Idaho sticker gate? Wild new insights? Haven't. Haven't. Little by little. I pay attention to Idaho, the gist of it, but I haven't been paying attention to any of the stuff in the last couple weeks, really. That's why I was like, maybe waiting to see what else gets filed. And let me just actually take a look and see if there was any other docs pops coming in. It won't shock me if we see. I mean, I would like I said, I would really like the court of opinion to come in um, for that part to be done and see what it says. Um, and yeah, so I won't. It won't shock me to see something, coming back out from McClelland and whatever, and probably Judge Fran Gull going deny, deny, deny. Now, sorry guys, is the 12th hearing still on or no? Thank you, 517. You have a great day. Hopefully, he's getting more insight from Kara. Have you talked to her, Sleuthie? Mm-hmm. Kara, she referring to Kara Weineke there? Or, I'm not sure how to say that. Weineke? I won't jump on any of these bandwagons. What about a wagon wheel? I'll jump on one of those in my mouth right now. Mm-mm-mm-mm-mm. Mm-mm-mm-mm-mm. SP, same. I'm safely Switzerland at this point. All right. Okay, does anyone else have anything to ask that I can't answer right now? I hate being out of my element. Documents, like I said, for me to read it, I get it. I get the gist of what's going on. But as for, trying to sound smart and explaining it all, ain't gonna happen. It's out of my element. Everyone has their fortes in life, and my twin sister, absolutely. If she wasn't such a bitch, I'd probably make her read this stuff and explain it to me. But she is, so I'm not. But anyways, so tonight we'll see if Ivy comes on. Charmaine, Aspen, of course. Myself, I'll just sit there and listen to them all talk pretty much on there. But yeah, it's the more I read something. Well, actually, the more I read something, I absorb it. You know, but I'm not usually one to absorb it all when I'm reading it. And I'm definitely not one to sit there and use big words like they do in the law stuff. But you like my accent. It's always so strange, eh? I say that to my husband, right? Who's British. I'm like, honey, you don't get it. Americans and Canadians drool over the British and Australian accent. Um, and then he goes, what accent? Right? So I it's the same thing. When you say that, I'm like, aren't we Canadians like the least people to have accents? Well, at least on the West Coast side, East Coast side. Yeah. They got the Newfie stuff coming over and stuff like that. But anyways, thank you. Kara also seems to get some insight from the from some shady YouTube era. I think that's what you mean. I can't imagine what these lawyers are thinking and planning. At what point do they run out of options? Right? Let's just play a little chess. I'll take this motion. Just because history. Sunny actually has an evil. I do have an evil twin. Yeah, yeah, she's a backstabbing, two-faced bitch like my freaking Satan sister. I hate my family. Did I tell you that? I hate my family. Honestly. Seriously. Such negative personalities. I probably like my brother the best. My mom's dead. My dad's dead. Um, older sister's Satan. Twin sister is just a backstabbing twin bitch who hates her life and everybody else is around it. Um, and yeah, my brother, he hasn't done anything wrong really. He just plays pool. Actually, my brother, if anyone's ever into like pool, right? Because he lived in England when my dad like held him hostage over there for a while. But anyways, he does like those pool trick shots, like where he jumps, swerves it around. Oh, crazy stuff. He goes to Vegas and does a lot of those pool tournaments. This is all predictable to me when Scion ruled that two lawyers be reinstated back on the case, or the judge had a huge problem with them. It wasn't a solution. It just fanned the flames and stuff like that. Yeah, you know. I mean, it would have been nice if things just would have went along according to protocol and smoothly. Heaven forbid that should happen for Abby and Libby. Heaven forbid. Oh, there's the little bitch. Hey. The clerk's office closes at noon Eastern today. So unless anything comes. Oh, really? Why? What's so special? What's so special, Adam? And again, if you guys haven't hit that like button, please consider hitting that like button. Hold on. I need a puff of my vape. I don't typically. I'm pretty sure Kara vapes. Isn't Kara vape? Pretty sure I've seen her vaping. Not Kara, Allie. Duh. I was thinking of Allie, not Bob's wife. Not Kara. My fast talking, almost a lawyer. We need you. Charmaine, don't tell Adam I said this, but I think you're smarter than he is. Shh. Don't tell him I said that, though. Aspen Con are good. We need a break. They always close at noon on Wednesday. Oh, do they? Really? I didn't know that. I think Aspen's rubbing chins there with Faith over at county clerk's office. Not sure. They told me they're leaving for today at noon. Okay. Well, according to my source, this being my source, they always close at noon on Wednesday. Yeah. Maybe a smart. Well, I mean, I certainly don't claim to be smart when it comes to court documents. And I'm not even going to try. Hell, most of these words I've never heard. I've learned a lot new words. Like I love learning new things, but documents, it's like reading instructions. They just bore. Like I'm interested in what some of them are saying, not all of them, most of them. But paperwork always, like when I was a general manager at the hotel, and you guys have no clue how much freaking paperwork I had to do. Like for someone that hates paperwork, and that's like my twin sister's forte, along with being a bitch. It was like the shit that I did was crazy for paperwork. And even I impressed my own self. I'll tell you, I just gotta tell you this quick story. You don't have to listen. You can go if you want to, if you're bored. But one of the first things that I had to do was there was about $13,000 worth of what's what I want to say, like basically fucked up money that was not paid. There was errors in the system, blah, blah, blah. Like I literally sat there. You guys have no clue how long this took, but like, meaning it took a long time, and I was amazed. I literally got that $13 down after sitting there with freaking um, file after file after file, and I got it down to that thousand, just a little over $1,000 was left unaccounted for. Like, meaning I went through everything. There was no accounting for it. Have no clue what happened with the rest of it. Anyways, um, but that was one of the first thing I do. And all I could think about, and this is what always gets me, all I could think about is, so how long did these effing lazy asses that worked at the hotel, including management, just keep overlooking it? Just keep overlooking it. You know how people always do that? Just overlook it, don't do it. And then somebody comes along that actually gives a shit to actually try to figure it out where this money went to and stuff like that. But it always amazes me. It's like, so you guys y'all just let 13,000 just sit there, when you guys could have tried to figure it out. Because it's funny at work when I was, I love things organized, everything in their file folders and everything organized so that you could do as quickly as possible. The fastest way to get there, I was all about, type of thing. At home, do not give a shit. My computer, I got files left, right, A, B, C, D, E, F, G drives. I'm telling you, they're all over the place. It's funny. But yet at work, I was always very organized. I know. But anyways, that was my one of my first things on the job that I was doing. And uh, payroll, never did payroll before. Was doing payroll. Schedules was easy, of course. Accounts payable. I remember then Eric, and Eric. Okay, you want to talk about a douchebag for a freaking. So there's a CEO, and then there was Eric, administration, whatever. Like what you guys deem as a slick Nick in a sense. Um, Eric was like what you would call the slick Nick, and he was so full of himself. Oh, freaking! I can't tell you how many affairs he probably had on his wife. But anyways, he was like an immature baby on there, and I was. Hold on. I can't remember what my point was anymore. I don't even know. I got too. I got too involved in thinking what a piece of shit he was as a person. Hearsay. Yeah. What was my point? My point's gone. Sorry. I do that. I distract myself. Whatever my point was, it's gone now. And it was a good one too, I'm sure. But I was talking about Eric because he's such a piece. He's like a car salesman. That type of dude. Can't stand cheesy car salesman type dude that are so full of themselves, so full of shit. I don't like the slick nickname. It's too Trumpy for me. I like the slick nickname. I like the tight pants video as well. That Charmaine blessed us with. No politics. I agree, Ivy. Tight pants should stick. Because they do. I know, McConaughey. Anyways, I don't remember what I was gonna say. I was talking about something. I'm sure if I hit rewind, I'd be like, "Oh yeah, right, the whatever." But anyways, sometimes I go like a tree and off like a branch, and then all of a sudden it's like, "What the fuck was I even talking about?" Anyways, you guys have anything else to say before we head out of here? Dun, dun, dun. Anybody? Anybody? Anybody at all on there? I don't know. Oh, that's what I was going to say about Eric. Oh, and Eric, right? So him and the CEO, of course, deal with numbers and shit all the time. Eric comes with this fucking stack, like you guys have no idea, of shit to do with the hotel. Depreciation costs, all this like this sales and blah 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 blah. Look, frick this sick. I look at this stack and I panic because he's sitting there with me and my husband, because my husband was me and him were both the general managers. And so my husband doesn't understand any of this shit either. But anyways, so Eric's talking to us, and it's total like, can I say this? Will it be offend anybody? It sounded like Chinese to me. Okay. like blah, 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 type of thing, not understanding you, don't understand the language at all that Eric is saying. Like numbers, blah, 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 blah. I need to absorb something. I need to look at something. So he's going off, and me and my husband are just looking at him like, the fuck are you even talking about? Like, we have no fucking idea what you're talking about. And he actually kind of looked at us like, are you guys dumb? Like, you don't understand what I'm saying here? No, because I've never seen fucking these stacks before. But once I sit down, so when I took those stacks home and then I read it, and then I can calculate it for stuff like that. Like, okay, I failed in math. I got a fucking F. After grade 3, I sucked. Okay, just putting it out there. Science, enjoy the beakers, didn't care, right? The little dead things that you play with and stuff like that, didn't care. The solar system might have cared about a little bit. Social studies, didn't care about that shit either. Okay, art, gym, anything that was home ec, shop class, anything that was creative and or sport like, I enjoyed. Language arts, okay, that one, okay, all right, okay, I can write a poem, no problem. My actual language arts things suck. I don't know where to put apostrophe half the time or where to use exactly all these punctuations. Honestly, I really suck at it, to be honest with you. Never gave a shit about any of those classes. Hence, when someone starts talking numbers to me, it's just like, it's just like, don't even understand it. Uh, okay, well, as long as you're offended, that was my intention. Um, if that's his raw. But yeah, when it comes to paper stuff, like I said, I just need to, like, here again, it's easy to absorb what was mostly going on here, absolutely. But it's kind of one of those things. Like I said, I couldn't sit there and tell you like what procedure is going to happen next, or blah 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 blah, or even say it in a way that sounds intelligent, really, to be honest with you. So if you guys just see me sitting there on a live and let everybody else talk, that's the reason why. Because just it's like after after a while. So I let Ivy and Charmaine and Aspen and Travis, I let them do all the talking for that stuff. And it helps me understand it more because I do love learning. I just don't like paperwork at the end of the day. Nick just needs to see Adam for hairstyle advice. Hmm? You don't like the grease ball look on there? I mean, yeah. I don't know. I feel like you could use a little trim around the edge there. Maybe we'll put a bowl over Nick's head, and do the freaking little bowl cut crew. Anyways, okay, guys, I think it's time to go now. It's kind of like I want to go, but I'm sitting here enjoying talking to you guys as well. Maybe it's just I'm enjoying talking to myself, to be honest. Actually, no, I came across a new program yesterday that I'm going to play with it. It looks like it does some pretty cool things on it. It wasn't doing what I wanted to yesterday. I was playing with, like I said, OBS because I really want to switch over to OBS. I just hate like OBS. Do you understand what I mean by that? When you have video capture, like you can only have one thing, and then I have to take it down unless I have another computer that can slide it over. But on OBS, you know how when you watch some of those lives that people have, and they can have 4 different things up at the same time, and blah 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 blah. I like that. Plus, it has the fun interactive stuff to go with it. We say boobly boobly, then we don't offend. Okay, boobly boobly, boobly boobly, boobly boobly. On there. Anyways, okay. Well, I appreciate you guys. Thank you guys so much for stopping by. We will see you later tonight if you're interested. And that will be at 10 p.m. Eastern Standard. Oh, this is because of Adam. Okay. 10 p.m. Eastern Standard Time and 7 p.m. Pacific Standard Time. That's amazing. Love to hunt. Who are we? Who says that? And can I join? No, Shireen, you can't. You're not almost a member on there. But anyways, you guys take care. Have a great one, and I'll see you guys tonight on tonight's live. And bye, Adam. You're smarter than Shireen. Oops, not true. Sorry, not sorry. And just trying to find the outro, guys. Okay, here we go. Bye.
One Norfolk night, the world is cold. We stand surrounded. We are not alone. We